Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3064, United States of America versus Thomas Webster, appellant. Ms. Brandenburg for the appellant, Mr. Goodhand for the appellate.
Morning.
Morning.
May it please the court, I'm Elizabeth Brandenburg for Mr. Webster. Good morning. This case was about bias. The bias of the chief complaining witness in this case, Officer Rathbun, was not permitted to be brought before the jury in this case, violating Mr. Webster's constitutional right to confront the witnesses against him. Officer Rathbun had been investigated for a officer-involved shooting that took place shortly after, some months after the events of January 6th. During the pendency of the investigation and preparation of this case for trial, Officer Rathbun remained under investigation while he was working with the government to develop the case. The government sought to restrict that information from being brought before the jury, and it was discussed in briefs as well as in a pretrial conference. At that time, counsel brought up the concerns of the relevance of this information, that the relationship between the U.S. Attorney's Office, the government, and the witness, while they were preparing for trial in this case, could come into play in their investigation. The government has contended that this issue was waived at trial. Our contention is that it was not waived, that it was fully litigated pre-trial and determined, especially in regards to the U.S. Attorney's Office investigation of the officer.
I'm looking at JA 824, and this was after it was disclosed that the investigation had been closed. And the government says, so there's no more, it was closed in his favor, no improper conduct found, so no reason for it to come in. Because the district court had previously said you could examine him about the fact that there was an investigation and that connection, or as you wanted to argue, that connection to the government. But once the investigation was resolved in the officer's favor, the government said, we request you not be permitted to engage at 824 of the joint appendix. And the trial counsel said, I think the government's position is correct. And so no longer sought to, said there's just no longer any basis for me to do this, and never tried to do it at trial. All the district court said after government said no, and defense counsel said, I think the government's right, was all right. So where is the district court ruling excluding testimony?
At that point at trial, Your Honor, the only issue that was still pending was the question of the investigation of the officer by the Metropolitan Police Department. We contend that the U.S. Attorney's Office investigation was argued and determined before trial and had been determined at that point. That counsel had argued about the relevance of it, that the government, the very same entity investigating and prosecuting the case, had investigated the officer involved. At the time of trial, or at the time of the pretrial hearing, when that conversation took place, the MPD's,
The one I'm talking about or the one you're talking about? I just want to make sure.
the one you're talking about, the
Okay.
MPD investigation was pending or thought to be pending at the time of the pretrial hearing. By the time of trial, it was determined and discovered that it was no longer pending.
Right, that's what I'm talking about.
Yes.
And at that point, as I read the transcript, government said there's no reason to allow inquiry now because there was no misconduct. It was resolved in his favor. There's no evidence of misconduct. And Mr. Monroe, trial counsel for the defendant at the time for Mr. Webster, says, I think the government's position is right here. And I think the government's position is correct. Having previously been told by the district court, you can ask questions about this investigation. And so the district court didn't really, just said, government said, we don't think you can do it. Defense attorney said, the government's right. And district court said, all right.
Well, I think
Figuring the parties had sort of resolved it and there was no longer an issue. So that's why I'm trying to find where in the record is the ruling post this discussion that you say the district court erred, where the district court erred.
there is not a ruling at trial beyond what Your Honor has described. The distinction I'm making is between the two investigations.
Mhm.
The U.S. Attorney's Office investigation, which was complete at the time of the pretrial hearing, and the MPD investigation, which was not thought to be complete at that time.
Mhm.
And so that was the only pending issue leading into trial, was the admission of the pending investigation.
The MPD one?
Yes,
Mhm. And that's the one that counsel said, the government's right, never mind.
yes.
Okay.
And our contention is that it wasn't waived because it was preserved in the pretrial hearing, but even if it was waived, that counsel was ineffective in that.
Okay, but why isn't it a waiver or at least a forfeiture? I'm not sure it matters for these purposes, what the difference, which label you want to put on it. Where is there any objection? I mean, the council clearly gave up the issue, so why isn't this at least forfeiture if not waiver?
Counsel gave up the issue in regards to the MPD investigation, had been previously argued in regards to the U.S. Attorney's Office investigation, and that having been determined not admissible at the pretrial hearing. So
The district court said that it was okay to ask about the fact of the investigation, the linkage, without going into the merits.
correct.
The investigation.
The pending investigation, the still pending investigation at that time. That was the only question still open for determination going into trial.
Mhm.
So our contention is both investigations should have been allowed to be delved into, but there is a distinction in the preservation between the U.S. Attorney's Office investigation and the MPD's investigation.
Where is the district court ruling? Where in the record is the district court ruling on so you're only arguing now about the U.S. Attorney investigation. I just want to make sure.
Not only, but there is, I recognize that there is a difference between the preservation of those two
Okay.
investigations and the issue.
Mhm. And where's the district court ruling on the U.S. Attorney?
It's not in so many words. I will admit to that, but on JA 233 is the discussion of where the counsel argued the relevance of that U.S. Attorney's Office investigation, and the court focuses more on the nature of the pending investigation, or that the investigation itself is pending, the one that is pending.
But it's the same. It's the same. You can talk about. You can ask about. So is your argument here that the court erred in not letting you get into the merits because the district court said you can ask about the investigation?
No, Your Honor. The contention is not that the merit should have been gotten into, but the question that should have been allowed was, have you been during the pendency of this prosecution of this case, have you been under investigation by the U.S. Attorney's Office?
Where did
Yes.
the district court say you can't ask that question?
What? I'm sorry?
Where did the district court say you can't ask that question?
The district court does not say that directly.
Or does the district court say it indirectly?
My
Is the
site,
district court error? You're arguing for district court error?
yes, Yes, Your Honor. My notes say that's at 2:33. The council had argued that he was, and I quote, not casting aspersions to the Department of Justice, but they've been very assertive in making sure that their relationship with Rathbun and them having conduct having cleared him in a separate shooting and his role in this case not be made part of public consumption. I think the public needs to know, just like the jury in this case would know, that there may have been a process in play where the Department of Justice clearing this officer because of his role in this case.
I don't see that on 233, but what I do say on 232 is the court saying, I don't disagree with that, except you don't get to ask him about the nature of the investigation. You just get to ask about the fact of investigation.
Yes, Your Honor.
And so what was the error in the district court saying you can ask about, cross-examine about the fact of an investigation? You just can't get into the nature of it.
I see my time has run. May I?
Okay.
The error was not allowing the investigation into what the U.S. Attorney's Office had been investigating the officer.
Again, where did
the quote I just provided was on 229. And the court conflated the two investigations as well as concentrated more on not getting into the merits, which was part of the discussion, but is not part of our contention of what should have been allowed.
The district court was given one answer, and that is you can ask about investigations, but you can't disclose to the jury what the underlying substance is because of the potentially prejudicial impact.
The court's ruling was that the pending investigation could be gone into about potential bias, not as to the completed investigation.
Greg, we'll ask you, with respect to your challenge to the jury instructions, these were jointly proposed and agreed to by defendant's counsel. So why isn't that invited error in this case, where the instructions were agreed to between the parties?
It's not invited error in that there's no evidence that it was part of trial counsel's strategy to induce the error, or even recognizing that there was an error to be had. That's the issue. The problem with the jury instructions was begun with the indictment in this case and how it put both ways of violating 111 through A1 and through subsection B into one count. And our contention is that while that may be permissible, that contributed to the confusion in this case in both providing the charges to the jury and also contributing to the constructive amendment that amounted from the jury charges.
It forced government to prove something more than what they had to prove just to get a conviction. How exactly does that harm your client?
Well, the additional or requiring both the elements from A1
Added
and
an
elements
extra
from B.
element.
Right, correct. But more than just that, the jury instruction did not, or it was not as specific as the indictment was as to what was the instrumentality of a deadly or dangerous weapon. And that has been found by the cases I cited from the 11th Circuit that this court has examined previously in Brown, that going from a specific indictment to a more broad allowance in the instruction amounted to a constructive amendment. In this case, flagpole was in the indictment and was not in the jury instructions. And there was evidence presented that could have supported other instrumentalities having been a deadly or dangerous weapon.
Is your objection not to the extra element, but simply that the jury instructions didn't say flagpole is the deadly weapon?
It's both. They go together, contributed.
I'm not sure they do. That's what I'm trying to understand why they do, because you're saying, sorry, the constructive amendment was that it allowed some deadly weapon other than the flagpole as to the jury instructions? Is that, so, but it's not, then it's not an extra element thing. It's simply specific to general, as you said.
We've raised it both ways, that the instruction was erroneous, both for adding the extra element and in constructively amending the indictment in the specificity.
Was there any evidence put into the record or any argument made by anybody that there was any weapon implicated in this case other than the flagpole?
Argument, no, but
Any
evidence.
evidence, yes?
Yeah, if the evidence existed as to when hands were placed on the officer, and I presented the cases that support that hands, your body can be a deadly or dangerous weapon, as well as when.
But no one argued to the jury that the deadly weapon here was hands.
No one argued to the jury of that, but the evidence was presented to the jury, and the addition of the
Well, the hands had to be presented because there's also the contact, the physical contact with the officer.
Correct. That evidence was presented as part of the assault. The extra element that was added contributes to the confusion in that regard, because the jury is looking at when the physical contact took place and when, whether a deadly or dangerous weapon was being used. And that exacerbated the issue with between the specificity and the broadness versus the indictment versus the actual jury instruction.
Any questions?
Just on the waiver, can you point me to where in your briefs you distinguished between the MPD investigation and the U.S. Attorney's Office investigation?
In our brief on page 5 and 6,
Right.
The quote that I read earlier and another quote from counsel and his concentrating on the issue of the DOJ's investigation is where we discuss that.
And then you're limiting 824 to MPD. That's where we get it. The waiver on 824.
Yes.
Okay.
Yes, Your Honor.
I understand. Thanks.
Thank you very much. We'll
Thank
give
you.
A couple minutes on rebuttal.
Good morning, Your Honors. May it please the court, David Goodham for the United States. Turning to the issue of the cross-examination, we do think that the defendant has waived that issue and wasn't simply forfeiture. To this.
Does it matter?
It doesn't. And
Could be invited error too, right?
it could be, to the extent that I think you read the argument starting at page 230, JA 235, all the way to JA 235. I think you read that argument as the court actually understood. I mean, I know counsel is now drawing a distinction between.
If we put aside, for the sake of argument, the MPD versus USAO point,
Yes.
which feels new to me, but if we put that aside, the statement on 824 is the government's position is correct.
Yes, and I do think that equals invited error. But and one final thing I'll say on this distinction between the two, that is pending versus completed. I look at JA 233 and I see the court saying to defense counsel, I heard you suggest that you want to ask him, there's a pending use of force investigation. So to the extent there might have been some ambiguity about what defense counsel was asking for during that colloquy, I think the court understood he was asking about the pending investigation. And in fact, you will see in that same 10 pages, the defense counsel asked for a continuance. You know what? We should just wait for this all to play out, and then we can determine if there was any finding of wrongdoing. So anyway, my core point is I don't think the court understood the distinction that's being drawn here, number one. Number two, we think it is an invited error, certainly with respect to the MPD investigation. Number three.
How can it be invited error if there was no district court ruling?
Well, there is a district court ruling, Your Honor.
No, the district court is all right.
Well, there are two rules. Oh, well, you mean with respect to the MPD investigation? Yeah, well, I think that, to my mind, that amount.
Error, because there's no court ruling. It's just the parties sort of worked it out.
I understood. I think, you know, in context, the court understood that the battle was about the pending MPD investigation. The parties work it out, and the court agrees that now that it's no longer pending, there's no bias.
I don't think the district court was making a legal ruling at all. That's why I'm just confused about the invited error thing.
I understand. I understand.
For forfeiture, but
I understand.
Invited error. There's no error by, not only is there no error by the district court,
I
there's no
understand.
ruling. I mean,
Sure.
you have to have a
Sure.
ruling.
Sure. And if this court disagrees, it's really.
You think all right is a ruling?
I think in context, given the battle back and forth between the parties, that
There wasn't a battle at that point. There was agreement between the parties at that point.
Or and the court
Battle.
and the court signed off on it. But again, you know,
You've agreed you don't want to, you can't ask, and you've agreed you can't ask. I don't think saying all right.
sure.
I don't want to read too much into a district court's words and start declaring it a ruling of any sort when parties have sorted something out and they go, okay, well, no, you can't. Yeah, I agree. I can't. And we're going, all right, let's move on.
I understand, and certainly.
I mean, maybe I'm gilding the lily too much. I mean, my instinct was the government's position is correct, is a stronger dissociation than just we're not pursuing this issue.
Sure. I mean, and, you know, certainly reasonable minds can disagree, but the core point here is even if we get past waiver and we're in the forfeiture context and we're in plain error context, it's impossible, I think, to understand that this amounted to either obvious error, but more critically, that it was substantially prejudicial. And, you know, to the extent that we're talking about prongs 3 and 4 here, I would just direct the court to the body-worn camera footage from Officer Rathbun. But more particularly, I would direct the court to the district court's description of that body-worn camera footage. And that's during the sentencing at JA 1907. The court says, I've seen that video more than probably anyone, and I still remain shocked. The video speaks for itself. You were the first aggressor, no doubt about it. You were the one who was taunting the officer, no doubt about it. You were the one with extraordinary force who brought down that flagpole. You took him to the ground, and that's all JA 1907. My point being that any incremental, minimal ammunition, if you will, that might have been gleaned via the cross-examination for bias of Officer Rathbun would not have substantially, the lack of it wouldn't have substantially prejudiced him. Your Honor, you know, I'd be happy to take additional questions. I wanted to clarify those facts on the record.
I had a question about I was brought up in the opening with the voir dire process. There was juror 1156 who said, Mr. Webster is disadvantaged with him on the jury and he wouldn't start at 0-0, or she, I can't remember 1156 gender. So I'm starting at 0-0, you're coming in disadvantaged.
Sure. Go ahead. I'm sorry, go ahead.
What I was just going to ask is, how can that possibly be someone who's allowed to get into the jury?
A couple things, Your Honor. If I might just
Sure.
get my transcript. Apologize.
Sorry, I'm bringing it up, so it's my fault.
Most fundamentally, with respect to juror 1156, and certainly I'm happy to talk about that sort of
Just how
question.
this person got through. You're not starting with presumption of innocence, you're starting on even ground with me. That seems very, very worrisome. And I should have thought the government would say someone like that just shouldn't be going into the jury pool at all.
Sure, I understand, but my core point with respect to 1156 is, of course, he didn't sit.
No, I get that.
Okay.
I'm just asking about confidence in because the whole.
Sure, I mean, I think.
The answer is, let's trust the voir dire process, and it.
Sure.
To me, at least in this concern, and I get your point that the person didn't sit. I'm just asking how it was that the government even would allow someone into a jury pool when they say, not even starting on an even plane, let alone presumption of innocence?
Well, I think the answer is on JA 324 and 325, where the court says, would you have any trouble in acquitting the defendant if you determined the government had not carried its burden? Unequivocal no from the juror. Then at the next page.
That doesn't deal with the starting point. That's the end point.
Um,
Right? And what it would take for an acquittal if not starting in an even point is different. I don't think that answers, I'm not starting with presumption of innocence. I'm not even starting with them on even playing field.
I think, I also think the next page, JA 325, could you evaluate, the court goes through, could you set aside your voting history, your political affiliation, evaluate the evidence in this case against a legal.
I'll set aside my political affiliation is, again, not the same thing as saying, I agree that I start with a presumption of innocence.
I understand the court's concern, certainly. Again, there's substantial deference that is assigned to the district court's assessment of the responses. There's demeanor, there's a question of candor.
I don't believe in the presumption of innocence, but the government's view is that person should still go into the jury pool.
I'm not sure that
They didn't even start on an even plane? Either not starting 0-0, I think were the words.
Well, and again,
How else do you understand? Am I misunderstanding that language? Is you are starting at a disadvantage? You are not starting at 0-0, which I take to be a level playing field. And of course, the law is not even a level playing field. It's an unlevel playing field against the government. The presumption of innocence.
Sorry, I'm just looking for the actual language.
I think it was maybe 330 or 331.
330.
I think that's what I have. I don't think of this as like a 0-0 game to start.
Right,
Could you
yeah,
start-
and right.
Could you start from a presumption of innocence? I honestly don't think so.
Sure, but then and part of this emanates from the fact that the defense counsel asked, would my client be disadvantaged if you concluded that he was?
And there was a direct answer that I can't start from a presumption of innocence. So
But then you look at when the court asks, and this is JA 330, what do you mean by disadvantage? And the juror says, I still presume the defendant to be innocent until the government proves their case. So to my mind, any ambiguity relating to disadvantage and that clarified it. So again, substantial deference is due the district court in assessing on the whole colloquy whether or not the juror is in fact willing and able to adhere to the rules and or be fair and impartial. But even putting aside that deference and even putting aside perhaps the ambiguity in this colloquy, again, the bottom line here is that that juror didn't end up sitting, and the court in Skilling was very clear. If a juror does not sit, even if you used a peremptory, that missing peremptory does not equal a violation, a constitutional violation in partial jury.
all right, thank you very much.
Thank you, Your Honors. We would ask that you affirm the judgment and conviction.
Okay, Ms. Brandenburg, we'll give you 2 minutes.
Thank you, Your Honor. I first would like to speak as to the last conversation about this disadvantaged juror. That's kind of how I call him shorthand. The only question that this juror asked, and which was answered, that was the saving grace for the court in denying the challenge for cause, was would he have trouble, and the court asked this question at least 23 times of different jurors. And this is a very problematic question, whether if the government carried its burden beyond a reasonable doubt, whether the juror could still, or failed to carry the burden beyond a reasonable doubt, whether the juror could acquit the defendant. This is a this is a question based on a false premise because a biased juror doesn't have trouble acquitting someone when the government has not carried its burden. A biased juror would determine in the first instance that the government had carried its burden. The question asks the juror to assume that the government has carried its burden and then, or I'm sorry, not carried its burden. It's a confusing question. At least 2 jurors were confused by it, one pointing out
You
the
did not
government.
raise that question as a challenge on appeal.
Well, I did raise the question or put in our brief that question was asked. And it contributes to what we've raised with that this juror who said that the defendant would be at disadvantage with him, what should have been struck, and that question permeated voir dire. We're asking the court to look at it, that question is problematic and the court in denying the motion for cause even said, that's what I'm looking for. When the answer to that question, it's a rote rehabilitation of the juror.
Suppose it were, assume for the sake of argument, that juror should have been stricken for cause. What do you do with Skilling and the other cases saying it doesn't matter if you elect to use a peremptory and that juror doesn't sit?
Well, I raised that question because that question is how that juror did get into the jury pool, answer to that question. And that question was asked of at least 3 jurors who did get onto the jury when discussing their previous exposure to the media coverage in this case. So it did that, the asking of that question did contribute to actual juror members being placed on the jury. And it shows that this was not the full thrifting voir dire that is described in Skilling, where the court was trying to get at the bias of jurors and the potential bias of jurors due to their exposure to pretrial media coverage. In this case,
You challenged, correct me if I'm wrong, I thought you challenged the seating of jurors 8, 13, and 19, correct?
yes, and I apologize.
So we just look at those colloquies and make a judgment whether those jurors were biased, right?
Well, I think the court looks at the entire voir dire to see if it was so infected that it didn't overcome the prejudice that existed in the veneer that the citizens of the district were faced with in having been in the district and inundated with the media coverage of the events of January 6th. So we would ask the court to overturn the defendant's conviction.
Thank you very much.
Thank you.
Case is submitted.
Case number 22-5273, Jo Spence, appellant versus United States Department of Veterans Affairs and Dennis McDonough in his official capacity as Secretary of the United States Department of Veterans Affairs. Ms. Spence for the appellant, Mr. Silverman for the appellees.
Good morning.
Good morning, Your Honors. May it please the court. I'm Jo Spence, pro se appellant. The district court erred when it failed to consider my second amended complaint in light of all filings and its evaluation under Federal Rule of Civil Procedure 12b-6, an EEOC versus St. Francis Xavier Parochial Schools, the DC Circuit held when deciding a Rule 12b6 motion, the court may only consider the complaint itself, documents attached to the complaint, documents that are incorporated by reference in the complaint, and judicially noticeable materials. In Brown versus Whole Foods Market Group Incorporated, the DC Circuit held that for pro se plaintiffs, the court may also consider the facts set forth in the plaintiff's opposition to the motion to dismiss. The district court, in this instant case, erred in its belief that it did not have to consider my opposition to the defendant's motion to dismiss simply because I'm an attorney. There's no language in Brown that excludes pro se litigants who are attorneys from consideration.
Do you have to have the pro se, the liberal rules to prevail? Can you win without the pro se liberality in pleadings, including the Brown versus Whole Foods rule?
I'm not sure I'm understanding what you're asking.
Can you win if we don't treat you as a pro se plaintiff? Could you win?
Yes, absolutely.
With that? So you could win just on the content of your complaint alone,
Yes.
your second amended complaint, without
Yes.
reference to the materials in your.
Well, no, the materials are crucial to my success here, and the court not
So then
considering my
you have to have a rule
materials.
that says for 12b6, we can consider materials attached to your opposition to the 12b6 motion.
Yes,
And as far as you're aware, that type of reading is only allowed for pro se parties.
well, that reading should be allowed, yes, to all pro ses. I don't know, I'm not aware of any, again, exclusion for any pro ses who are of any particular profession.
Why would we extend the rule to pro ses who are attorneys?
Well, just,
That rule itself is an exception to normal pleading rules.
well, just
And
because,
the rationale is that pro ses generally aren't lawyers, but you are.
I am a lawyer, but just because someone carries the title of attorney doesn't necessarily mean they have the requisite experience to litigate, to file their complaints without defects. And I've not represented the federal government in any litigation before a federal court before, even though I'm a former federal government attorney. And that role is reserved for the Department of Justice attorneys. So I don't believe I should be penalized simply because I carry the title of attorney.
Ms. Spence, even for pro se litigants, though, we have a number of cases saying that pro se litigants must follow the rules. And here the district court repeatedly suggested to you ways to make your complaint compliant with the rules. And so even if we were to give you pro se treatment, I mean, there are a number of cases, I mean, pro se litigants still have to follow the federal rules of civil procedure.
In this case, the district court's claims that I repeatedly failed to follow the rules, especially with regard to his page limit, are not supported by the record. And the record shows that with my first proposed amended complaint, where I sought to add count 6, that was denied by the court without a reason, and the court imposed a 50-page limit. My second proposed amended complaint was denied for violating the court's page limit, but I misinterpreted the court's order and included or added 50 pages for count 6 to my original complaint, which was 98 pages. So any violation was totally unintentional. A third proposed amended complaint was denied after the court erroneously found that a 57-page statement of facts attached to my amended complaint was incorporated by reference. And I have to note that that exhibit was one of 3 Merit Systems Protection Board documents attached to my complaint. and only one was singled out as being incorporated by reference. The district court also erred when it found that the exhibits attached to my opposition memo were also incorporated by reference. There were no indicators that any of the exhibits were to be incorporated by reference. And then with regard to my last attempt to avoid any further erroneous claims of incorporation by reference, I submitted a 48-page fourth amended complaint, and I filed that with no exhibits or no attachments. So as far as I can tell, my complaint was compliant. There were concerns that my complaint did not comply with Rule 8A2 of the, that was count 6 of the complaint of the Federal Rules of Civil Procedure, but the complaint itself was compliant with the court's orders, except for the one instance where I misinterpreted the court's order. The district court, I'm sorry, the DC Circuit was emphatic in Brown when it stated that a court errs when it fails to consider a pro se litigant's complaint in light of all filings, including filings responsive to a motion to dismiss. The district court erred in its findings that I provided no facts for counts 1, 2, and 3 of my complaint that could possibly give rise to an inference that any actions taken against me were due to race, sex, or age, discrimination, or retaliation. The district court erred in its failure to consider the facts of my opposition filings, which contain the facts necessary to make an inference of causation. Further, the court's refusal to take judicial notice of the exhibits attached to my opposition memo violated Rule 201C of the C2 of the Federal Rules of Evidence, which state that a court must take judicial notice if a party requests it and supplies the necessary information. The district court erred in finding—
Judicial notice is for matters that are not reasonably in dispute, and while your attachments were very much reasonably in dispute, that's not to say who's right or wrong, they don't qualify for judicial notice. Those are for matters traditionally public filings by the government that are not matters in dispute. And I'm having trouble understanding how your attachments, your exhibits would have even qualified for judicial notice.
Well, I was just following the Federal Rules of Evidence. It did not contain a qualifier. It just says for if a party requests judicial notice and supplies the necessary information, then the court must.
That's not what it is. It has more than that. There's a definition of what qualifies for judicial notice in the Federal Rules of Evidence.
Well, thank you for that lesson. The district court erred in its finding for count 1 that the employment actions I complained of had no binding effect on my salary, bonus, or other benefits. The district court erred in its findings that I did not establish a causal connection between those employment actions and my protected activity, and my termination was the only adverse action I suffered. My opposition filings, which contained sufficient factual matter to plausibly establish the elements of my claims, stated that I suffered numerous adverse actions. One was a fully successful performance rating I received, which was lower in 2017, which was lower than the outstanding rating I received the previous year that resulted in the loss of a monetary award. In Weber versus Batista, the DC Circuit held a performance evaluation to be materially adverse when it results in the employee not receiving a cash award. The district court erred in its failure to consider the facts in my opposition filings. The district court erred in its findings that I did not plead a causal connection between my termination and my EEO complaint, and that dismissal was warranted because I was terminated nearly a year after I filed my November 6 EEO complaint. My amended complaint states that the original EEO complaint was amended numerous times and that the alleged events of discrimination and retaliation occurred between November 2017 and September 2018. In Singletary versus the District of Columbia, the DC Circuit noted that a close temporal relationship may alone establish the required causation.
Okay, thank you. Thank you very much. We'll give you a couple minutes on rebuttal.
Thank you.
Good morning, Your Honors. Bradley Silverman for the government. The district court's action in this case was a reasonable and proportionate response to the problem that confronted it. The plaintiff was a trained attorney with 36 years of experience who, despite the district court's repeated instructions to limit her pleadings to 50 pages, repeatedly filed pleadings in excess of 50
Can
pages.
you just explain the confusion? The first time she thought it was for the new amended claim. It was a mistake on her part. She admits it, but nothing willful. And rules do allow attachments to complaints. And so she just says it was matters of confusion. Do you dispute? Do you think she was engaged in deliberate and willful disobedience of court orders, or just was rather confused?
Yes, Your Honor.
That
I
was
can't
the
speak.
or question. Which one is it? She was rather confused, or she was deliberate and willful in defying the district court orders?
I cannot speak to her state of mind, obviously. I can't look in her mind, but there are two aspects of this case
What's the government's
that
view? Do you
raise.
think, I mean, if you've dealt with litigants.
Well, and
You've heard her explanation today.
there
Do you have
are
any reason not to credit her
Yes.
explanation?
two reasons not to credit it, Your Honor. First, the district court's directive was unambiguous. It is difficult for me to understand how a reasonable person, let alone an attorney, can read the district court's order, which very clearly said your amended pleadings, not your new count, your amended pleadings.
Well, again, she said she thought that meant the amended pleading was the addition to the amended complaint. Mistaken.
The other
But
reason,
that doesn't suggest willfulness or deliberateness.
well, it does suggest willfulness and deliberateness and sort of cast doubt on that previous explanation is the subsequent actions in this case. First, attempting to incorporate 57 additional pages into the complaint. And second, in her response.
She's confused about judicial notice rules, and she's confused about rules for attaching, the rules about your ability to attach things to your complaint. And when she was told, every time she was told no, she did not repeat that step. Did the district court find that she was willful and deliberate?
I need to look at the district court's opinion, but the district court did find that she repeatedly violated his orders, that Ms. Spence is a trained attorney who reasonably can be expected to read an order and understand it.
Negligence. I didn't read this as finding willfulness and deliberateness and that she was just someone in the face of the district court. But you do.
Your Honor, I can't read.
I'm asking you how you interpret, how you're the government, whoever the trial counsel was, interpret it.
I find it difficult to understand how a trained attorney can read the same order over and over again, limit your pleadings to 50 pages, and repeatedly violate that, first directly, and then second and third time indirectly by pointing to voluminous external materials in order to supply the necessary facts, the ostensibly necessary facts missing.
Government not move for summary judgment on, motion to dismiss or summary judgment on all of her claims?
Government moved to dismiss all of her claims except for one record review claim where the government moved for summary judgment.
Right. I thought it was summary judgment.
I'm
I
sorry?
thought it was motion to dismiss or summary judgment on all claims. I get the district court only granted summary judgment on one, but I thought the government's motion was either one in the alternative.
It might have been the primary thrust of the
It would
argument,
make sense for her then to attach things to her opposition
but that
or
doesn't,
summary judgment motion and to argue about them.
but even if those materials could be considered in the context of ruling on a summary judgment motion, they can't be considered in the context of ruling on a 12B6
I
motion.
understand.
So the court could still dismiss under 12B6 without needing to or being permitted to look
Sure, but it
at.
doesn't make error for her to attach those things to her opposition.
Well, it is error when you're pointing to those to supply the facts missing from her pleading. It's important here to look at what she said in her opposition brief. I'm paraphrasing here a little bit, but the government moved to dismiss on the ground that she had not pleaded facts to give rise to plausible inferences. In her opposition, she says, paraphrasing, well, yes, I did not plead the facts because this court limited my pleadings to 50 pages. However, if you look at these exhibits, you will see the necessary facts. So that what this shows is that she was not simply providing these
The court
exhibits.
only objected to the statement of facts. She did not, as she has pointed out, object to the other attachments at any point.
The government only pointed to the statement of facts. There was never a ruling or an argument. There was never any consideration as to whether the other materials violated.
Confusion again, right? No, confusion.
There is only, the other materials may well have been improper as well, but we had only
On what
argued.
basis did the district court dismiss with prejudice?
Three considerations. The three considerations this court identified in Bristol Petroleum. In Bristol Petroleum, this court,
I don't want Bristol, I just want you to tell me in this record, what basis did the district court dismiss with prejudice?
with prejudice. First was the fact that Ms. Spence had had repeated opportunities to amend her complaint, to file a compliance complaint, yet had not done so, had required the government to file 3 dispositive motions, and had repeatedly violated its orders as a trained attorney. In light of these considerations, the same factors identified in Bristol Petroleum, the court determined that dismissal with prejudice was appropriate given the opportunities Ms. Spence had been given, the burden that her conduct had imposed on the court and the opposing party, and the need to deter other parties and promote respect for court orders.
Is it the government's view that, having been enlightened by the district court, she could not plausibly make the allegations to state her claims?
I'm sorry, Your Honor?
Is it the government's view that she could not plead any factual allegations to support her claims? Not, you wouldn't agree to them,
Sure.
I assume, but that she could not?
In theory, possibly. I don't know what the actual facts are. It's possible that, you know, the facts as they exist in the world would not support a plausible claim, but that was, our argument was that there was not that there was no conceivable set of facts in which she could plead a claim. It was that despite being given numerous opportunities to do so, she had not done so.
I understand that point. That's good. And then I just have a question about the count 6. This is an MSPB one. I know it's very long, but it seems quite clear to me what she's arguing there, lack of substantial evidence. Again and again, again, this lacks substantial evidence, this lacks substantial evidence, this lacks substantial evidence, which is what one argues in an MSPB appeal. So if she had just said one line in her complaint, the MSP decision was erroneous because it was unsupported by substantial evidence, would that be sufficient to state a claim?
I'm not sure that one line, but at least probably not many more lines.
Well,
than that
what
one.
would she have to say?
Just explain what the MSPB did, and then briefly say why.
Okay, but what she did was she disagreed with lots of things the MSPB did. She identified them and then identified why, in her view, they lack substantial evidence. And if she had just picked one aspect of the decision and elaborated on it, when she later tried to raise other ones, you would have said that's not in your complaint. If she just said the decision lacks substantial evidence, you would have said that's too little. But she did here where she went with all her disagreements and said and didn't just say it lacks substantial evidence, but explained why, in her view, it lacks substantial evidence. I'm sure you disagree on the merits, but she did that. So what exactly was wrong? Was she only allowed to identify 5 or 6 things she disagreed with on substantial evidence? Or I just don't understand what she was supposed to do if, in her mind, as she has explained, there were, I don't know, 20 different things that MSPB did that lacked substantial evidence. How was she supposed to plead that?
I don't think it would have been difficult to explain as a general matter what she believes the administrative judge, the MSPB judge, did wrong as a general matter without diving into the weeds of every particular detail.
That just gives that gives the government even more notice. There's no notice problem here as to what she was arguing. I mean, as I read it, it's pretty straightforward. It was essentially a brief, right? It had every point on which she thought there was a lack of substantial evidence, but that's not a notice problem.
It was,
So the government, and one can imagine somebody who hasn't litigated before not wanting to leave something out on the grounds that someone will later say, well, you'd never raised that in your complaint.
well, it was a notice problem, Your Honor, because it was very difficult to look at this and know what facts mattered. It's true, there was an enormous.
I don't think so. You read it and she goes, here's a ruling. Here, it lacks substantial evidence. Here's why. Here's another ruling or finding. Lacks substantial evidence. Here's why. Here's another ruling. Lacks substantial evidence. Here's why. You couldn't read that? You didn't see that when you read it? Because that's what I saw when I read it.
I saw it, but it's very difficult to look at this through all the detailed factual allegations, most of which concerns irrelevant or.
Well, that would be your answer, is that that was not material to the board's decision. But to her, it was relevant and important and lacked substantial evidence. I wasn't sure why we were pick out a complaint that gives you more notice because you think it fails.
Because Rule 8 doesn't require the opposing party to need to dive through an enormous sea of irrelevant information or less relevant information in order to pick out the few pearls of relevant and important information. What notice means in this context is not just that it's dumping every conceivable fact in front of the district court, but that it actually makes clear the basic thrust of its claim and what matters, rather than require both the court and
But the basic thrust of the claim you said wouldn't be sufficient. Her basic thrust is MSPB's decision lacked substantial evidence, and its factual findings were relevant, lacked substantial evidence. But you said just pleading that isn't enough. You need to lay out a little bit more. And then I'm really kind of, I feel like there's a betwixt and between here, because if she does the minimal one, that's not going to be enough. She did the maximal, she gets kicked for that. And if she does something in between, she's going to be leaving out allegations to her, in her judgment, were important mistakes by the MSPB. Again, you can disagree on the merits, and you can even group them together in a response. But how was she supposed to know which ones to leave out when they were all, in her mind, important errors by the MSPB? What was she supposed to do?
So I perceive two questions there. Let me try to answer them both. How was she supposed to know what to plead and what not to plead? By exercising.
No. Which errors?
Yeah.
Not to raise. When to her, they were all important steps in the contribution to an erroneous judgment.
So let me answer. You asked, well, if she pleads too little, then she's out of luck. If she pleads too much, she's out of luck. There are two separate rules here, two separate independent requirements, as the McHenry case recognized that this court relied on or cited with approval in Sorowski. Rule 8A imposes one requirement, and Rule 12B6 imposes another requirement. And in order to plead a valid claim, you need to satisfy them both. So maybe the one line claim would not have violated Rule 8A. It would have been kosher under that rule, but it would have been a problem under Rule 12B6. They're both required. Now, as far as knowing, feeling that every single fact is important, this is one of these areas where a lawyer is expected to exercise some judgment in culling all of the facts that seem relevant in one's mind and putting down those that actually are the important, the operative ones, not just everything that one, thinks will matter in the case.
Suppose I agree with you that on dismissal with prejudice of count 6, which flows from this extended back and forth on a pleading that violates the too much principle, right, the 8A problem. How does that support dismissal with prejudice on counts 1 to 4, which are the opposite, the Twombly-Iqbal too little problem? It just seems like those were kind of in suspended animation while there was all this back and forth about count 6 having too much detail.
Well, the district court did not dismiss the first 5 counts because of the problem with count 6. The district court dismissed the first 5 counts because of Mrs. Spence's, dismissed with prejudice, excuse me, the first 5 counts because of Ms. Spence's behavior over the course of the case. So you're correct that it would not be proper to dismiss the other counts because of the issues with count 6, but that isn't what the district court did. Ms. Spence had been given numerous opportunities to plead counts 1 through 5, which were the counts raised in the original 98-page pleading. She'd been given repeated opportunities to plead these counts in a way that complied with the federal rules and with the district court's order that she limit her pleadings to a fairly healthy, robust 50 pages. After 5 opportunities to do so and failures to do so, it was within the district court's discretion to say that Ms. Spence would not be permitted to continue to burden its docket, the other parties, to deprive attention from other litigants before the court, who the court was able to devote less time to because it kept having to come back to Ms. Spence.
All right, thank you very much.
Thank you, Your Honor.
Spence, we'll give you 2 minutes.
Counsel's claims that I repeatedly violated the court's orders and I had some behavioral issues just are not supported by the record. And although I was given numerous opportunities to present to the court a compliant complaint, some of those opportunities were missed when government counsel claimed and the court agreed that I incorporated documents into my complaint by reference when I did not. And opposing counsel standing before you today was not able to explain how it was that only the statement of facts attached to my amended complaint was put in a category of being incorporated by reference when there were 2 other exhibits, all of which were MSPB documents already in the record, already, they were all identified as exhibits that were attached to the amended complaint. So yes, while I had opportunities, some of them were unnecessary, that I had to go back to the drawing board, even to the point where, as I stated earlier, I felt compelled to submit my 4th proposed amended complaint with no attachments for concern, out of a concern that I would get another warning from the court about those documents being incorporated by reference, even though, again, there were no indicators that they were incorporated by reference.
Were you intentionally breaking the court's rules?
Pardon
Were
me?
you intentionally violating the court?
Absolutely not. I would never do that.
Any questions?
On the count,
One more sentence and then you're over your time.
I'm sorry. On count 6, I will just say that count 6 was compliant with Rule 8 of the Federal Rules of Civil Procedure. And thank you for recognizing that I did make out claims there so that the government could understand, and it was not the disorganized and convoluted claim that the district court and the government would have this court believe. Thank you.
Thank you very much. The case is submitted.
Case number 23-1024, NextEra Energy Resources LLC and NextEra Energy Seabrook LLC petitioners versus Federal Energy Regulatory Commission. Mr. Estes for the petitioners, Mr. Kennedy for the respondents, Mr. Konopka for the interveners.
Morning.
May it please the court, I'd like to reserve 3 minutes for rebuttal. FERC claims that the text of the LGIA in this case, mainly section 9.7.5, creates an ongoing obligation for Seabrook to upgrade the breaker at significant uncompensated cost for the benefit of future competitors. Avangrid never mentioned 9.7.5 below, and FERC never mentioned it until the rehearing order. The only mention comes from ISO New England, a party, who says it didn't apply, that it did not create any obligation on Seabrook to upgrade the breaker for future competitors. And when we look at the text of the document, ISO New England was correct. You can find it at J 325, 326, and the whole case turns on it. The first thing we see when we look at the text is we're given a couple of interpretive aids. The parties intended us to read the text in accordance with the ISO New England operating documents. FERC tells us in footnote 1 of its brief that the tariff is one of those documents, and that figures in when we look at the specific obligations the agreement creates.
I do want to hear what you have to say, but I just need some table setting here. I just want to make sure I understand what's in dispute in this case, because I thought I saw in your brief that you don't have any problem. You don't oppose, you don't deny the ability of, if I'm saying it right, Avangrid to, or Avangrid, I guess, to connect. This is all really a dispute about, and you'll get your construction costs. It's all really a dispute about whether you will get some of the other costs that you have referenced in your brief, the opportunity costs and things like that. Am I right that that's really what's at issue here? Because it sounds like you're about to get into things about, you know, the authority to have the connection, but it sounded to me from your brief that you're not vetoing, you're not saying they can't connect. It's just that you don't feel like FERC's decision about the type of compensation you get is sufficient. Am I right, or am I misunderstanding things?
You're exactly right, Judge Millett. If FERC had said, you have to do this, and we're going to make you completely whole, we wouldn't be here. We would be concerned about the policy implications of that ruling, because this agreement is all over the country. There are many situations where it exists. But we wouldn't exist. We've agreed to make the upgrade. But FERC leverages a misreading of the contract into claiming it can force us to make the upgrade and dictate that we get half a loaf of compensation. So we need to take this bit by bit, because they claim the parties agreed in the LGIA, despite the no third-party beneficiary language, that Seabrook has some open-ended obligation. We need to cut that off and then get.
I'm sorry. I understood your argument to be the opposite, which was you were arguing that you did have a right to veto the connection by Avangrid. And then in the alternative, and only as a fallback, that if you were wrong about that point, you were at least entitled to opportunity costs. Am I wrong about the first piece? That was the whole point.
We interpret the contract to not force us to upgrade the breaker. We agreed to upgrade the breaker nonetheless, as a matter of commercial negotiation, if we're made whole.
But you're still challenging
We
the
are.
first part of that.
We are, because
That would
that's.
be a very
you're-
big
you-
concession otherwise.
Yes, no, we're challenging the first part. We're just saying that doesn't mean we're refusing to upgrade the breaker. We just want to be made whole when we do it.
But your position is that you can refuse to allow Avangrid to connect, even if they compensate you for opportunity costs and lawyer costs. Or not.
Is that
If you want to give that up, that's great. That'll narrow the case. But I thought you were pressing that point.
Our position is that the LGIA does not obligate us to upgrade the breaker.
Period. Full stop.
Period, full stop. If we're not saying FERC doesn't have other tools in other contexts, if we imagine someone just saying we're not doing it, we're never upgrading this breaker, go pound sand.
Can I just, sorry, I just want to clarify because
Okay.
it sounds like two very different answers. I thought your argument was that FERC doesn't have the authority to order the circuit breaker replacement without full compensation payment, I'm not sure, without full payment of lost costs.
Our position is that the LGIA does not give FERC any basis for ordering Seabrook to upgrade the breaker.
No matter what the.
No matter what, FERC would have other tools in that situation it can employ, which I'll talk about. But the LGIA
It doesn't
doesn't.
matter because you said you're happy to replace a circuit breaker as long as you get full costs. It doesn't matter, it doesn't.
Which FERC has.
Which means if we just come down to the question of what cost do you get or not, then
Well,
we're fine, because you're happy to replace it.
Our position is that the contract doesn't obligate us to replace the breaker. Commercial negotiations between the parties can yield terms under which we're made whole, and we do so. And we've always agreed to go down that road. That's not what happened because Avangrid complained that we were a transmission owner and we were blocking their entry. FERC ruled we were not a transmission owner, but nonetheless ordered us to upgrade the breaker and did not provide for full compensation. We fight the basis for the finding that we have to upgrade the breaker. We fight jurisdiction and we fight compensation. You don't have to reach the compensation issue if you rule for us on the first two issues. Which brings us to the contract.
Okay, so just.
I'm sorry, Your Honor, if I'm.
No, so you have no intention of replacing the circuit breaker with Avangrid paying construction costs.
Did you say we have no intention?
Right, you're not willing to replace the circuit breaker. If you win on the first ruling, or even the second, if you win on the contract or FERC doesn't have power, that's it. You're not removing this, you're not replacing the circuit breaker.
That's not correct, Your Honor. We've said repeatedly that we are willing as a matter of just commercial negotiation to do this. We're not trying to block a competitor. We're not trying to create a catch-22. We just want to be made whole. And FERC's
That
tool,
makes me feel like what you just said was your third question is your first one. If you get the costs that you want, we don't have to fight about what the contract means because you're willing to do it as long as you get full costs. We don't have to fight about FERC authority because you yourselves are willing to do it if you get full costs. Is that understanding correct?
if we were made whole, we would replace the breaker, but that's not what the FERC order says.
On your own, regardless of.
As a matter of commercial negotiation with Avangrid, which is the way most of the power business does business, actually. Commercial negotiation between the parties without regulatory compulsion.
So okay. All right. I think I understand where.
I'm sorry if,
Chris,
yes.
let me maybe switch gears a little bit. I'm wondering, what remedial authority, in your view, did FERC exercise here? Because it doesn't suggest that it's operating under Section 206, right? Are they operating under Section 309, their general grant of remedial authority? Where does their remedial authority come from in this case?
Well, they granted a complaint filed under 306, under 206, but they didn't really say, Your Honor, and we don't think they have a basis for authority. That's one of the problems here. They've interpreted a contract and inserted their own point of view about what the words should mean, though the words don't say that. And so they are claiming authority is given to them by the parties in the LGIA when the parties did not give them anything like that.
To make a determination under 206, FERC has to first find that the existing rate or term is unjust or unreasonable. But did they make that finding here? I mean, if they had made that finding, then they could have amended the tariff. Do you think that would be within FERC's authority?
Your Honor, I agree completely with that, and we said this on brief. The LGIA is a dog that doesn't hunt, But FERC has other tools. One of them was to create a 206 proceeding to examine whether the ISO New England tariff should be changed. They did that and abandoned it. They could have changed their whole fabric of interconnection facilities under 206.
Where does Seabrook challenge this remedial authority? Do you raise this challenge that they didn't have remedial authority? I mean, you challenge their jurisdiction, but do you challenge their remedial authority?
We challenge their interpretation of the LGIA, which is where they claim the parties gave them authority. So that's really what they're saying.
You filed in the 206 proceeding as well. You asked them to say that the compensation you were getting, Avangrid would be
We filed for
unreasonable.
We filed for a declaratory order and they ended up
Under
dismissing.
206?
No, a different provision of the Federal Power Act, actually, but they didn't go down that
What
road.
did you file under?
Your Honor, I can't tell you right now where in the
I
Power
had a
Act.
complaint under, I thought two parties came with a single dispute to FERC. You said one complaint was under 206 and I had thought yours was in that same proceeding.
It was, we filed first, we filed for declaratory order,
What did you file under?
we filed for
The
declaratory.
order is under pursuant to FERC regulation that allows parties to seek declaratory orders.
Are you asking if there's a regulation?
I mean, isn't there a regulation that
Yes,
allows
there
parties
is.
to seek?
And there's a part in the statute where this is envisioned, I do believe. Then Avangrid filed a week later a complaint. This was in 2020. FERC ended up granting the complaint in part, basing its decision solely on the LGIA. So they're claiming they can interpret a private contract and find the obligations they seek to impose on us from the text of that agreement. It's not in the words, however. That doesn't mean FERC didn't have other options. You're exactly right, Judge Rao. They could reopen the rules governing interconnection. They could change the way ISO New England does things. They also, by the way, if you really want a rifle shot to deal with competitive blockades, if somebody was saying in some other part of the country, you can't make me do this, it's 23 cents to fix it, but we want $23 million. FERC has a provision in its regs, because generators sell at market-based rates, that you have to tell them every 3 years, we're not erecting barriers to new entry. They never went down that road. That's not what we're doing. They looked to the contract, and when you look at the contract, it does not carry the weight FERC describes
So
to.
FERC suggests that because Seabrook is required to follow good utility practices, that they are required to do this upgrade before Avangrid connects. And FERC repeatedly points to good utility practices as being found within the contract itself. And so I'm wondering what you think about that argument, right? So their argument seems to turn, their contractual argument places a lot of weight on this general term, good utility practices. And then it says the contract is highly relevant to understanding what a good utility practice is.
Well,
So why shouldn't we, defer to FERC on its determination about what a good utility practice is?
Well, if you look at the text of the contract, you find it doesn't support FERC's reading, because 975 does incorporate good utility practice. If you turn to the text, you find the answers to a lot of what we're discussing. We're told at the very beginning of this provision, we're supposed to look, the parties wanted us to look in two places for just general guidance, in accordance with the ISO New England operating documents. The tariff is one of those, for Katsas in footnote 1. Okay, we'll need that in a moment. And in compliance with good utility practice. If you look at J283, that is defined. But it sets out means to an end. It doesn't set out the end. It says you have a desired result. You're supposed to take one of maybe several different measures, doesn't have to be the optimum one, but things utilities generally do to accomplish that result. And you're supposed to do so at reasonable cost, consistent with, among other things, reliability and safety.
Isn't a good utility practice, though, the way that it's defined suggests to me at least some type of industry standards.
Yes.
Right. And
That's
so,
right.
So FERC is saying an industry standard here is requiring Seabrook to do the upgrade. So why is that? I assume you think that's wrong. Why do you think that's wrong?
There are several reasons it's wrong. One is they've never done anything like this before, so no one's ever been in this posture. But if you look at the language, good utility practice is an interpretive aid. We have duties under the provision that FERC cites. we are supposed to accomplish those duties using means consistent with good utility practice. But it doesn't tell us what the duties are. So we still have to look at the language as FERC does, but not very fairly to the words, to see what we're supposed to do. Whatever it is we're supposed to do, we have to do in accordance with good utility practice. And we wholeheartedly agree. We need to watch out for reliability and safety. Absolutely. But that does not mean the words
You
say
have a
what FERC.
contractual obligation.
We have a contractual obligation, but Your Honor, we're also NRC licensees and we're talking about work inside
I'm
the
not
power
talking
plant.
about that, but I'm talking about, you have a contractual obligation even as to because the ISO is a party to the good utility practice clause.
Yes,
And to
it obligates
help
us.
maintain safety and reliability of the grid.
Well, you have to
Of your operations as they connect to and affect the grid.
it doesn't give us a freestanding obligation to do things. It tells us when you're,
I think,
but
to borrow Judge Rouse' question, that part of good utility practice is to operate consistent with industry standards. And I didn't think you disputed that.
we are doing that right now.
Well, but if industry standards are that circuit breakers are supposed to have a 4 to 5% margin of error, and you have a 0.4% margin of error, how is that? I mean, your circuit breaker is hanging by a thread.
Your Honor, I
There's nothing, I don't think there's anything that can connect to the entire grid now that won't require a replacement of your circuit breaker. Is that right?
we don't know about anything. Avangrid can't connect. But the circuit breaker,
If you're virtually at capacity on the circuit breaker. Is that correct? I mean,
there is enough room for the circuit breaker to operate reliably without an additional interconnection, which is key.
No, stop.
According to
Time
the,
out. Can any other entity come on the grid, any other source of energy, come on to this, anyone, a reliability repair, any increase in generation occur without you replacing your circuit breaker? Given that it's right at the cusp?
almost certainly so, but the record doesn't really tell us.
No, but
Well,
really?
Your Honor,
You're at 0.4%?
the way this tolerance works, and we put in expert evidence, Avangrid has its experts, we put in ours to say, this percentage is not a problem. There's headroom.
What you said is this is not a problem on the grid now.
That's right.
And my question is, because you joined an ISO, and ISOs have all kinds of rules about allowing new energy in, new producers in. And the FERC has spent a lot of time coming up with the non-discriminatory rules for that. So you're on a grid, you're not a solo operation here. And did your expert witness say that anyone, FERC mentions all these other people in line to connect, can any single one of them connect without you changing the circuit breaker?
Your Honor, let me go back to what actually happened. And
No, you can do that after you answer my
Okay.
question. Can any other generation at all, or even an increase by someone already on the system, occur without this circuit breaker being replaced?
Your Honor, I don't know the answer to that question.
Okay,
The
so your
record,
expert didn't say, in response to FERC saying all these other folks want to join, they can all join, it's just something about Avangrid.
no, it's a question of ISO New England doing really complicated engineering studies about power flows. Avangrid's line hooks up 100 miles from Seabrook, which sounds like a long way away, but there's a beeline of a transmission line that goes straight to the substation outside of Seabrook Station. So Avangrid's also 1,200 megawatts. That's a lot. That's a big change to power flows in the system. If you had other people doing other things in a less electrically proximate place on the grid, probably it would be fine, but I don't know the answer to that. And ISO New England never.
The standard is 4 to 5% margin of error, and you're at 0.4.
We disagree with that standard, Your Honor. And
And what evidence do you have that there's a different industry practice or industry standard of error?
we put on an expert who explained that Avangrid's math is wrong. The NRC said.
That's not telling me what the industry standard is.
below 100%, you're fine.
The industry standard is, so if you were at 99.9, that would be hunky-dory with the industry. That would be consistent with safety and reliability.
Yes, Your Honor.
And your experts.
Well, I mean, we would have to ask the experts potentially, but yes, the headroom issue
No,
is
that
a
would
false
be-
issue.
No. I'm just asking about these questions. So, so you have expert testimony in this record that says it's industry standard to have a circuit breaker, perfectly fine, even at 99.9%.
It doesn't say that, Your Honor. It says that
You just said
the
that,
percent,
so you said under 100.
I think that, well, I don't think the expert affidavit says that. It says we're fine where we are, and it
If
explains
no more power comes onto the grid.
other interconnections can change that. We don't know which ones. The reason why there's a bit of a lacuna here, Your Honor, if I may explain, is that a big project was in the queue, 1,200 megawatts. It was a straw that broke the camel's back. So ISO New England told Avangrid, you have to fix this. Go figure it out. Every subsequent interconnection was modeled with the assumption that the breaker would be replaced for Avangrid. So we do not know the answer as to what else would happen. It is true that if Avangrid pulled the plug on his project, there probably is some other project that would then have to, that would then trigger this need. That is true. But the electrical sequence of studies, the sequence of electrical studies doesn't work the way that allow me to answer the question. I'm sorry, Your Honor. We don't have that information. We do know Avangrid's project creates a problem. We know that our breaker is fully reliable now. The NRC said so, and FERC doesn't disagree.
Can I ask you back to the tariff? I'm sorry, the interconnection agreement. There is a specific duty with respect to circuit breakers. It incorporates good utility practice, but it says that customers like Seabrook shall provide, install, own, and maintain circuit breakers, plural, and all other devices necessary to remove any fault contribution of that facility to any short circuit. Doesn't that seem to contemplate not just a duty at the moment of Seabrook's entry on the grid to have an adequate circuit breaker, but an ongoing duty to upgrade it as necessary for the grid?
No, Your Honor. Let's take the words. The first part of what you read says that Seabrook's supposed to provide, install, and own and maintain a circuit breaker.
Right.
The first three, it's already done, okay? It maintains the circuit breaker right now every 18 months. The record says that at JA 491. The circuit breaker is supposed to be necessary to remove any fault contribution to any short circuit occurring. It's not otherwise isolated by basically New Hampshire transmissions equipment. That happens right now too. The circuit breaker is fine for existing conditions. The question is, for sure, what about the future?
Right.
And when you read this language in light of good utility practice, it does not create a contractual duty, and it's implausible to imagine that the parties intended to create one, for us to upgrade the breaker now when it's reliable for the benefit of a third party. There's a clause against third-party beneficiaries, and
It will be inadequate if some other generators, including Avangrid, are allowed onto the grid.
well, remember the first phrases when I said it incorporates the
So it
parent?
seems to me like this provision cinches up FERC's case unless you can point to something else which prevents other generators from seeking access to the grid.
And I can.
And I'll let you, but I just, for framing purposes, I'll just tell you that seems pretty unlikely in a system, a regulatory system whose whole point was to encourage independent generators to be able to have access to transmission facilities. But go ahead.
Well, I'll start with the words and then I'll get to the policy. They're both really important. The first phrase of this provision says we're supposed to read it in accord with the tariff. And as we said in our brief, the tariff makes it legally impossible for Seabrook to interconnect without the breaker being upgraded. So the idea that there's a,
Based on what provision? Is it?
at JA 724 I.3.10 puts the onus on Avangrid.
If they impose a significant adverse effect on transmission facilities of
Right.
another market participant.
So our position is, Your Honor, that the,
Okay,
whatever,
there are a couple of problems with that.
Okay.
One is if we're really fussy about reading the words literally, this provision only applies to transmission facilities, and FERC has said this is a generator facility. It seems a little artificial to me, but even if I give you transmission equals generator for purposes of this clause, it just says unless Avangrid takes action or constructs at its expense facilities necessary to mitigate the problem.
Judge Katsas,
And that sounds more like they have to pay for the upgrade than they have to pay for lost profits and attorney's fees.
Your Honor, the tariff says that if there's an adverse effect determined by the ISO on the system of one or more market participants, Seabrook is a market participant. Goes on to say the market participant or transmission owner who's impacted. And it says that the new interconnectee must take such action at its expense. So it's not just building, it's fixing it. This is also the fabric, Judge Katsas, of the way interconnections work for the last 20-something years. You have a decision up front.
Sorry, bear with me. I'm just trying to find it. Where are we?
Well, we're at JA 724.
724, right. I got
In
it.
the middle of the phrase, it says adverse effect on a transmission owner or the system of one or more market participants.
Okay.
So Seabrook qualifies. There was a big fight about that, Your Honor, before, and this is part of the,
Shall not to proceed to implement unless the new party imposing the cost, which is Avangrid, takes such action or constructs at its expense facilities necessary to avoid the adverse effect.
sure.
That, to me, to my ear, that could reasonably be read to say they have to pay the cost of upgrading the circuit breaker. That's their obligation, constructing such facilities to avoid the adverse effect.
The way it's been read since the words existed is that the interconnecting company has to work things out with the system it's affecting. There has and that's a question of commercial negotiation. There's no regulatory oversight to check and see what the payment stream should be. They just have to go work it out. But if you go look back at the language and see what the obligation actually is, you see that this is not a situation where existing resources on the grid have an ongoing duty to pay tens of millions of dollars, perhaps, to upgrade their facilities for the benefit of a new entrant. That is,
Is it your contention that that is the good utility practice, that good utility practice ordinarily involves this being through a commercial negotiation? I mean, do you have evidence of that as being the industry standard or the industry practice?
that's what ISO New England said below, that people work these things out. And most of the utility business is worked out, particularly under good utility practice, through coordination and negotiation. That's the way almost everything is done. It rarely is the case, there's regulatory compulsion. But if you go back, you're on.
The negotiation is going to be completely different if you start with a veto power.
We don't think we have a veto power, Your Honor. We tell FERC every 3 years we're not going to erect barriers to new entry. We think we have the ability to be compensated reasonably and made whole.
Back to where we started this whole argument,
Right.
that I don't think you disagree with anything Judge Katsas has read to you. It's just you have a dispute about what, you don't have any dispute that Avangrid can come in as long as it pays construction costs and you have a different definition of construction costs. Isn't that what this is about? You say, that, you know, the cost of putting this circuit breaker in need to encompass all your costs, your money loss, not just whatever it takes. I'm sure this is a big operation to get this big thing in there, but it's also opportunity costs. I don't know what else you're including in here. I don't know where the attorneys, I guess if there's litigation, the attorney's fees. I just want to make sure, I keep coming back to thinking that that's what the fight is over, is you're not saying you can do a straight up veto. You're saying that what that contract means is they got to come in and pay the cost of this change. And the way your position is, the way those costs should be figured out is not FERC's interpretation, but between contractual negotiation. Is that your position?
We don't think the contract authorizes FERC to order us to upgrade the breaker. We're willing to do it if we're made whole. We don't, but FERC is refusing to make us whole based on the contract.
So you don't think, you disagree then with Judge Katsas at least proposing one reading of this language as you have an obligation to let Avangrid do it as long as they pay. You signed up and you have your arguments, you've made your arguments about that. But one possible reading is you've signed up for this as long as they pay what's referred to as construction costs. And that's, I don't understand how you don't have you can say you don't have a veto and saying, we can stand here with our arms crossed and say, we are not doing it. FERC has no authority and you won't give us everything we want.
We have a veto under the contract.
Your answer to Judge Millett's question is you have a veto, but you have chosen not to exercise.
That's a much better way to put it, Judge Katsas. But I do think that
Gives you
FERC,
a
I do
veto.
think
Just to be
though,
clear, the contract gives you the veto, or is there something else?
we think the contract allows us to say no. That's true because it doesn't dictate that we do anything
That's
to hook
what
up,
you veto.
to hook up a new resource. It is, there's a no third-party beneficiaries clause and it deals with the three parties to the contract.
Well, what if, when we're to say this is a group activity. This is the ISO, right? It's a group activity. You get the benefit of all different transmission lines and all their reliability. If one goes down from a storm, you've got others. The customers get the benefit of many, many different sources of generation. If one goes down, for example, you're planning to go down for your own maintenance, whatever it is in the fall, but customers will be okay because there's other generation on the lines, correct? But that's how this system works. It benefits you, it benefits customers, you benefit others by being there, but it's a group activity.
It's a tight power pool run by an
It's a
RTO.
group activity.
Okay.
You're not the only generator and there's lots of transmitters.
It, okay.
So if everybody else on the grid says, we need more electricity, electric cars are coming, fossil fuels are going down, the demand for electricity is expected to increase astronomically in the next 10 years. If they said that, then allowing someone to interconnect wouldn't be just a benefit for Avangrid. It would be a benefit for the system of which you are a part. Correct? Under my hypothetical? I'm just betting.
I guess, Your Honor, but
So when they let, and if FERC says the way the country benefits, the way our electrical system benefits in this country is to have ISOs that allow new power in without discrimination, conditioned on them paying the costs of entry. And that's what's best for each grid individually. And FERC said that's what's best for ISO New England here, and that's what's best for our electrical system and for keeping the lights on and for making allowing America to function. Then it's not a third-party beneficiary issue, right? It's the system that's been set up. The benefit is to the system of which you are a part, correct?
there are many things about what you said that I disagree with, so I can't just say that's correct, but let me.
The benefit is to, not just to Avangrid, but to the system. I think you already agreed with that.
A benefit to Avon Green interconnecting is to the system as a whole. I don't know that I would stipulate to that, Your Honor. But I really do have an answer to your question. And I'm afraid, I don't know why I haven't been able to get it out. Let me try one more time, okay? There are lots of tools in FERC's tool chest. This is a big activity and it's very carefully coordinated. There's the ISO New England tariff. There are rules about interconnection. They get revisited a lot. They were revisited in 2003 and they were revisited in 2013. They say nothing about the issue we're talking about here, though FERC is free to change that. There also is an interconnection agreement that's a form contract customized for this situation that's been in place for a long time. That's what FERC relies on. What we're saying is it doesn't carry the water, Judge Millett, that you want to put there. Other things could carry the water. The system can be.
What else? Is there something else that FERC missed that would take away your veto power?
Well, if they wanted to change the way interconnections worked, they could say, and in fact proposed to, they ordered ISO New England to show cause why we shouldn't change the tariff to say in New England, we're not even going to study generators like Seabrook. Whatever happens to you happens, it's up to you to fix it. That would have changed this supposed veto.
How about they did this? FERC says this contract, good utility practice plus 9.7.5 means no veto power if the interconnecting entity is willing per the language to pay full construction costs. FERC say that?
There's no plain meaning basis for it, Your Honor.
I'm not saying I'm saying could FERC, and whatever this proceeding is you want them to do, a 206 or whatever, could FERC say that?
Yes, they could have a
And it would apply to
rulemaking.
you and to Avangrid, or are you saying it wouldn't be retroactive?
There would be a file rate doctrine problem. But they could change the rule set anytime they wanted. They proposed
Would
to
it
do,
apply to you going forward?
they changed the rules. Sure.
But you didn't challenge that here, did you? You didn't challenge that they lacked the remedial authority or that they didn't exercise the correct remedial authority here.
Well, Your Honor, I disagree with that. We challenged the authority they offered. The only thing they said they were relying on was this agreement. We then pointed out, being accused of trying to strangle competition, which is wrong, that there were many other tools FERC had available they chose not to use. The problem you're posing, Judge Millett, of what about, all the different demands on the system? That's a really important question. It should be addressed generically, and FERC has plenty of room to address it, but they chose not to go down that road. There's a big problem, though, embedded here, Judge Millett, when you imagine the future, okay? If FERC wants to change the rules to require incumbent resources to pay half the tab for new interconnections, that's a big change. That's not what the rules currently are, and it will introduce cost uncertainty. We talked about this below, and FERC just never answered us. Projects are financed all around the country right now. Here are your interconnection costs. It's in a box. The banks come in, the lawyers look at it. Okay, we know what this is. You're financed. You're good to go. There's no situation where the grid can say, guess what? Somebody new came in. You got to pay their cost, half of their emission fee. That's not how it's worked for 20 years. The background rules are completely different, though FERC could change them.
The evidence of your half the admission fee. Everything I read in your books, in your brief said, there might be lost opportunity costs. There might be litigation. Of course, you're in that now. There might be other expenses, but everything was hypothetical.
I disagree, Your Honor.
Okay, where did you show concretely that you will, since you're already taking yourself online and yourself down, right? They're doing this at a time when you're already offline. And is this 23 days like the other one? Or I don't know, how long are you going to be off this fall?
We don't know exactly what the costs will
Do you
be.
know how long you're going to be down this fall?
The outage was scheduled for 10 days. We expect it to be another 10.
Do you think 20 days? Is that?
We expect 20 days, full stop. We will be off an extra 10 days. When we calculated these numbers before, that looked like about 5 million. It might be 20 now, but it's a lot of money either way. There are other sorts of costs that might come to roost, other problems, other that there could be accidents in the installation. We asked to be made whole for all of that, and we filed a formula rate to do this because Avangrid was saying we were a transmission company. And so this would be regulated. FERC has formula rates all the time, so we laid out the components of our costs. We always said something was going to, there was money here that we think we should be able to collect. And we've been consistent about that the whole time. FERC acts like the outage might not need to be extended, and they claim after they've assumed contractual authority groundlessly to order us, and after they've assumed jurisdiction groundlessly to order us, they say, we get to control your compensation, and we need to put the incentive on you to shorten your outage. So we're going to just say, you have to eat whatever, bad things happen as a result. Yep. Judge Millett, you wrote a decision a year ago called Citadel, and Judge Katsas, you were on the Belmont case about incentives, and those were about situations where, FERC's handing out ratepayer money, and the ratepayers say, wait a second, these people can't respond to the incentive. This is money for nothing. And you send these cases back saying that seems to make sense. FERC wants to put the onus on us to cut corners doing delicate surgery inside of a nuclear power plant. We can't respond to that incentive. We have to do what we have to do.
FERC said it's just not going to upfront license anything, costs that may come along later, because then you don't have the incentives. But as of now, we don't know. For all we know, the circuit breaker could go in, be fine. It would be within your 20-day window, and there wouldn't be these other, that's possible.
Well, no,
Is that impossible?
the window's 10 days. We're saying we need another 10. That's going to happen in September.
Sorry, I'm sorry, you need another 10 for what?
To put the breaker in. We can't fit it in our existing outage window. And I don't think the federal government should be trying to tell us, make it happen to save your own money. Why is protecting Avangrid's purse more important than protecting Seabrook?
Avangrid said they can put it in this fall window.
There was a debate about that, but it's impossible.
No, has Avangrid said they can put it in?
They did say that.
Okay.
They thought.
There's a factual dispute about things that we don't know are going to happen in the future or not happen in the future.
Your Honor, when we were in a regulated utility world proposing our formula rate, we took care of the uncertainty by definition because we said we'll look backwards as formula rates do. If the outage really didn't need to be extended, then Avangrid doesn't pay a dime. If it does, we'll calculate the different charges consistent with the formula rate. It's all under FERC's rate regulation at that point. And we'll work it out, and there could be a fight. We won't ask for anything imprudent. But if FERC now says you're not providing any electric service to Avangrid. So we say, this is a matter for commercial negotiation. We'll have a contract. You pay us what the price is. We can have a retroactive look back. We can have arbitration to fight about if there are disputes. And that would take care of it too. Either way, you could deal with the uncertainty. But why is it fair to have an existing generator pay substantial uncompensated costs?
But we're not talking necessarily just about fairness. I mean, I've asked several times, but what is your evidence that good utility practice in this circumstance where you have a generator and you have a new transmission line connecting? You said these contracts have been around for 20 years. What's your evidence that good utility practice doesn't require this type of upgrade?
Your Honor,
I mean, there are no generating companies coming in here in support of NextEra saying, this is we're worried that this is going to happen in the future under our interconnection agreements, that we're going to be required to do this.
Your Honor.
I mean, it seems to me that you need to have you need to have some sort of evidence that FERC is wrong about what good utility practices require in general.
Your Honor, everybody's been boiling the FERC oceans for a while here. No one's come up with a single prior case where an existing generator anywhere around the country under the terms of the LGIA has been required to reach into its pocket and pay money to interconnect. So
you say there are no examples of
there are no examples of this. This is the first time it's ever happened. And my real evidence, Your Honor, is on the page of the LGIA. It doesn't create that obligation for third parties. There might be other ways FERC could create this obligation, for sure. Now, I haven't gotten into jurisdiction. There's been no prior case where FERC has ordered a change in generation equipment prior.
Just one last question from me. Assume you have a tariff governing your sales. With that tariff, if you get saddled with losing profits, would your tariff allow you to pass that loss on to your utility customers, or could you amend your tariff to allow that?
No, we sell under market-based rates. We sell at the price the market will bear. This is a fight between two very large power companies. Nobody else pays for it. It's one or the other.
Thank you very much. We'll give you a couple.
Thank
minutes to
you.
rebuttal.
Good morning, Your Honors. Robert Kennedy on behalf of the Commission. Before getting into 9.75, I just want to touch on some of the questions that Your Honors raised with Seabrook's counsel. Judge Millett, you asked, essentially the question is, if it's not Avangrid, it's going to be someone else who's going to come on and push this breaker into overduty status. I think if you look at JA 537, which is ISO New England's brief in response to the Commission's briefing orders, it indicates that there are a number of projects in the interconnection queue, and all of them sort of are dependent upon the circuit breaker. All of them assume that the circuit breaker will be replaced to have sufficient headroom to allow these new projects to interconnect.
Mr. Kennedy, even if that's true, what does that have to do with their contractual obligation to upgrade? Like, it might be that there are other people looking to interconnect, but what is that? I mean, FERC's argument is that the contract required
Correct.
upgrade in these circumstances. So I'm not sure what those other facts in the world even have to do with that contract.
No, I'm just answering the question. No, absolutely. The Commission's determination here was based on the fact that under both Section 1.32 of the tariff, Section 4.3 of the interconnection agreement, there's a broad obligation for Seabrook to operate, maintain, and protect its facility in connection with good utility practice. The Commission then looked at Section Appendix C, Section B3, and Provision 9.75 of the interconnection agreement to glean what that means. Does good utility practice require you to make a change to your facility in response to the changing topography of the grid?
So Seabrook's counsel says there are no examples of this. Where, they have these interconnection agreements, they've been around for a long time, and FERC has never interpreted these agreements in this way. What is your response to that?
I agree. This is, and the Commission notes this in the orders, this is a unique circumstance because in the typical case, you have changes to transmission facility. A generator wants to interconnect, or a new project wants to interconnect, and it necessitates changes to the transmission facilities. There's a large body of case law on that the Commission draws upon in its orders here. It is rare that in the study process that generators be identified as parties that are affected by an incoming project. And there was some discussion in a sort of the 206 piece of this case as to the practices of other RTOs and the like. So I think for that reason, my understanding is that ISO New England is somewhat unique in that it identifies, it studies impacts on generators in its interconnection process. So I think that's why this is sort of a rare case. It's also a rare case because this, most generators, this is an old facility. It's hooked up in 1990. Most generators are somewhat newer, and they, as a result, have more headroom in their circuit breakers. So most times an interconnection wouldn't impact.
But FERC's rule here, FERC's order here would seem to have general applicability to any parties that have a similar type of interconnection agreement. A generator in these circumstances where there's a new transmission line would be required to upgrade.
Correct. I mean, that is the Commission's position, that under section.
Yeah, so it's not just for these parties. I mean, that like where the interconnection agreement has similar language.
Correct.
FERC's view is good utility practices requires this type of upgrade.
Correct. Just as to why this hasn't come up before, I think it's a unique situation given the way the interconnection studies are run and just the nature of this very facility. that it is impacted because it's already almost at capacity.
It seems like there are various provisions in both the tariff and the interconnection agreement, which they don't squarely apply by their terms. But one way or another, they illustrate the principle that when a new entrant comes in and the connection will impose costs on others, the new entrant has to pay those costs. So what's the rationale? That's the basic principle. What's the rationale for excluding opportunity costs, which seem like they're real?
Well, the commission looked at, first, just kind of getting back, it could possibly be real, but getting back to what we ended on with Seabrook's counsel, there is a dispute in the record as to
Okay, but your position is categorically.
Correct.
No opportunity costs can be subject to this obligation, that imposed on the new entrant to compensate.
Correct. And that's kind of the baseline rule that the commission established in the generator interconnection context.
What's the
and
rationale?
rule? The rule is that A, it can be difficult for interconnecting parties to project what those costs may be, that the party doing the upgrade is in control of the schedule and whatnot in the engineering when they're working on their own facility. The commission did have a carve out that if parties come to an agreement on it, that's fine. But the pro forma rule is that lost profits and opportunity costs are not generally recoverable. And in this case, the commission looked to maybe start the interconnection agreement because the obligation to upgrade is grounded in that. Section 9.71 of the interconnection agreement says, with respect to compensation for outages, look to the tariff for any compensation that is due. So the commission did that. It looked to section 1.3.10, which we were speaking about earlier, and it looked at the language there, and it poses upon the incoming party, the interconnection customer, the obligation to pay for the cost to construct the necessary upgrades, and the commission viewed that as the cost to engineer, procure, and install. And I think that's sort of consistent with this court's decision in the Southern Companies case that's cited in our brief, where the commission interpreted language saying the interconnection customer is responsible for all costs. The commission interpreted that as direct costs, given sort of the backdrop.
And similarly for attorney's fees, background rule is the American rule. Each state bears their own.
It has been
costs.
Yes, that's really limited to the direct, what the tariff says, the cost to construct. And that's certainly, that's, if you look at sort of parallelism, you look at Seabrook's interconnection agreement, section 18.2 of that, obviously, which dealt with the upgrades necessary for their interconnection, it excludes lost profits and the like as well.
Okay, you said, just wanted to pick up one word, you said generally they're excluded when you were answering Judge.
I'm sorry, generally.
You said they're generally, things like opportunity costs are generally excluded. What I'm wondering is why you had that qualifier, and if, for example, this were to take place and then through no fault whatsoever, in fact, through every best effort by Seabrook, something happened, weather or something, that caused it to take longer than expected. I get why FERC upfront doesn't want to license all this because of its incentive concerns, but is there any mechanism after the fact, if there ended up being significant costs through no one's fault and everyone's best efforts, does Seabrook have any capacity to go back to the commission and say, look, it's just and reasonable to have them pay for this, or it would be unreasonable not to let them have this, or to have us split the cost of, not right for New England, but a hurricane that came along?
So
Is there a post hoc capacity, but FERC, for obvious reasons, doesn't want to?
So I want just to get to the first part of your question, why I said generally, it's because in Rule 2003A, the commission left open the possibility if the parties agree to lost profits and the like.
Oh, that was
That's fine. as to your question, I mean, if you look at, and I think it's paragraph 104 of the initial order and the commission does note that at this point, it's speculative whether there will be any costs and the like. And its ruling does hint at maybe down, we don't know what's going to happen. But I will say at the end of the day,
Is there anything that would bar them from coming back and?
Well,
Or
I will
we just
say-
don't know how this works.
I will say at the end of the day, what the commission is doing here, it's interpreting Avangrid's responsibilities under the tariff. I think it's interpreting tariff language that limits to the cost to construct regardless of the circumstance. So while there is a little bit of ambiguity and the commission does note the speculative nature of the cost at this point, based on the facts that we know now, I think logically the commission's ruling is grounded in the tariff language, which is not dependent on the future. And the commission says,
Avangrid isn't a party to the tariff, though, is it? I mean, it's not a party to the contract.
not a party to the contract, but the commission's interpreting their obligations under section 1.3.10 of the tariff and the schedule for electric transmission upgrades, which says when you're coming on, this is your responsibility, the cost to construct. So that's what it's interpreting with respect to why the extent of Avangrid's cost responsibilities.
And how do you square? Oh, sorry, strike that.
So I was going to, because it seems odd that if really the rub here is they want protection against these unknown indirect costs that might actually never happen. But either FERC or we are supposed to decide that right now. Doesn't seem right, because they're just entirely speculating whether they're going to have excess costs. It's just not known on this record whether they will or not. But if they have no opportunity, if they have to get them up front, because FERC would not entertain, and after the fact, yikes, look what happened. We need to have compensation for this on a record that, full good faith, full every reasonable effort, and sometimes things just go wrong. Then they do have to litigate it now. But if they could go to FERC afterwards, then it would seem like this question about whether they can, under the contract, get these extra costs as part of the construction process that triggered the problem. Then it could be decided later with a real record as to what they incurred and why, and whether it fits within FERC's conception of what the construction project entails.
Again, I obviously see your concern with ripeness and the like, and the speculative nature of these. And again, the commission did point to it, which obviously you can see the appeal of coming back later with a complaint and saying circumstances have changed. But again, I'm not.
They can't do that then.
Well, I'm not sure logically how the subsequent facts would change the commission's core decision here that Avangrid's obligation is limited to the cost to construct the necessary facilities, which the commission has interpreted here as the direct costs.
Procedural bar to them coming back.
I don't think there's a procedural bar, and
They would have to say,
and you
this should count as construction costs, X, Y, and Z happen, perfectly reasonable, and we have to say.
right, or this wasn't. So I'm sorry.
Oh, you please. You've got more instances than I do.
No. I'm just saying the argument was made. Look, this is confiscatory potentially at the end if we're out of service for a year or whatever it may be. And the commission said, well, then, no, that's speculative. Whether they could bring that back, I don't think there's a procedural bar. I'm just saying, given the logic of obviously, I'd like to say yes, they can bring it back. Maybe this will all go away, but. The logic of the commission's decision here is that we're talking about Avangrid's tariff, what the tariff obligates Avangrid to pay. And that seems disconnected from whatever the facts may show.
Mr. Kennedy, if you could clarify for me, what remedial authority is FERC exercising?
So I think.
Because FERC brought a sua sponte 206 proceeding, which it then abandoned.
Correct. In the So as you know,
Yeah, so what authority is
so I
the
think
commission
in
exercising?
the, I think it's in its general authority, in the complaint order, in the complaint, Avangrid did cite the commission's general authority under section
Under 309?
3. Yeah, and I think that's what it's doing here because it's just, and again, there hasn't been any challenge to this, but it's just interpreting, it's not finding that a provision is unjust and unreasonable, it needs to be changed, it's just interpreting the scope of the party's present day.
So I mean, if I
obligations.
assume I disagree with FERC's interpretation of the contract, then to reach this result, wouldn't FERC have to do a 206 proceeding?
Yes, if your honor believes there's no existing obligation and the commission wants to impose sort
A
of
different
reciprocal obligation.
They would have to find that the existing arrangement was unjust and unreasonable
Right.
and then impose a new one.
Correct. And as you were discussing with Seabrook's counsel, obviously there's filed rate issues there and we dealt with this in the PJM context and I'm forgetting the name of the projects at issue there, but it becomes difficult when you're trying to figure out what rules should apply to a project that's working its way through the queue. But yes, if there was no obligation here and the commission wanted to impose one, it would have to do so through section 206.
Okay. And so in FERC's contract interpretation, it seems to me that the commission is placing a lot of weight on good utility practices, that good utility practices require an upgrade in these circumstances. And I'm wondering what good utility practice the commission can point to that suggests, if an upgrade is required here, about which I'm a bit doubtful, but if one is required, why doesn't it include the payment of indirect costs? Because it seems like there should be some parallelism there.
Well, the commission talks about this in the rehearing order. So I guess getting to the second part first about the costs. The definition of good utility practice discusses things widely done in the industry. The commission's point with respect to that is outage costs, lost opportunity costs are generally not permitted recoverable in the interconnection process for parties that have to go through it. You see it in the tariff for generators that are affected by outages. You see it in the commission's case law regarding transmission owners that are affected by the interconnection need to go down. That lost profits and the lost opportunity costs aren't generally coverable. So what the commission said in the rehearing order, that demonstrates that that the industry goes through with these projects without the assurance that, without the opportunity to recover these lost profits and the like.
So what happens in Judge Millett's nightmare scenario? They're offline for 6 months for nobody's fault. They're just getting crushed. They charge market rates, so they can't pass on these costs because competitors aren't getting crushed in this way. Is that just a risk of doing business?
Well, again, I think the commission does base some of its rulings on the speculative nature of these costs. But I'm repeating myself at the end of the day,
saying when they come back with this ex post as applied challenge, the answer is going to be the same.
I think that's the logic of the commission's orders here, which are based on the language of the tariff itself. It's not saying it does raise some issues with the speculative nature of the damages, but I think at the end of the day, what the commission is saying here is the Avangrid's cost responsibility is limited to what it says in the tariff, and that is the cost of construct, which
is what it is.
Yes.
Yep,
Yeah.
right, but there's a force majeure clause in the contract. And so if that were the cause, I assume FERC has not answered this question of extraordinary, costs due to circumstances beyond everyone's control, how the force majeure clause would play into that obligation. Or I assume someone could argue that this actually, pointed to common law or whatever, counts as construction costs, and then FERC would have to address that once they had something concrete. Now, answer might be no, for the reasons I've said in the past, but if they haven't addressed this type of this type of extraordinary problem before, or the implications of force majeure clause, then that would be for FERC to answer later, and then courts could review the reasonableness of its decision.
I think that's correct, Your Honor. There is no procedural bar. Just in my discussion today, I didn't want to suggest that it's just a completely open playing field.
I completely appreciate your candor.
But yes, I'm not aware of any procedural bar if they were to come back with sort of the what's called the nightmare scenario.
Mr. Clay, so if FERC hadn't issued this order here and Seabrook didn't upgrade its generator, when Avangrid was ready to connect, would Seabrook be in violation of the tariff? I don't see how they would be in violation of the tariff in that situation.
Of the tariff,
Or the interconnection agreement.
well, under the commission's interpretation, they're obligated under section 9.75 to undertake this upgrade because the grid is going to change when they.
But where in the words of 9.75 is that obligation exist?
So I think it's in, obviously they need the general thrust of 9. And I'll get to the specific language. But the general thrust of 9.75 is you need to have circuit breakers in place and you need to maintain and operate them in accordance with good utility practice. Now, sort of the question is, does that mean I need a circuit breaker in place sufficient to protect my facility and my contribution to faults on the system based on the specifications when I hooked up? Or what the commission found, no, it's an ongoing obligation and you may need under these unique circumstances here to upgrade in response to the grid as it exists now. You have an obligation to operate your facility and maintain it in accordance with good utility practice throughout.
This contract is a bilateral contract. It's not a contract with the world.
Well, it's
Anyone who may want to hook in.
It is with ISO New England, the operator of the grid. And the facts here are that ISO New England undertook its study process and said, once the Avangrid project hooks up, the breaker will be over duty.
Exactly. Once it hooks up, then they would be in breach if they didn't upgrade.
Correct. And the commission's interpretation of section 9.75 is you have an obligation to, obviously, you don't want to go through the scenario and say, okay, yes, you have to respond to the grid as it exists. We're going to let this project hook up and then you have to upgrade. You want it beforehand logically because the idea is to
Well,
protect.
you might want that, but then maybe that is just left to ordinary commercial negotiations.
Well,
It's not an obligation, because there's no breach, right? When does the breach occur? Like, when is Seabrook in breach? Like, if Avangrid says like, okay, we're interested in connecting, why is Seabrook in breach?
because they are refusing to operate their, protect their system in accordance with good utility practice when they're.
So it's really all about the good utility.
And it's
practices.
essentially,
I mean, at the end of the day, that is like FERC's primary argument.
well, yes, and the language of section 9.75, which requires them to protect against any short circuit occurring on the system.
But
And
you can't point to any case, any situation or any case or order where FERC has required a generator to do this.
no, as I
Within the
said,
transmission line.
I think it's rare that generators are identified as affected parties in this
So does FERC
circumstance.
just sort of have a free-floating ability to identify new good utility practices? Like, it seems like good utility practice refers to something in the world, like industry standards that are established, that Seabrook would be on notice that they have to do because it's something that occurs. Like, and if FERC wants to make a change, then they can go to 206, they can amend the tariff. But they didn't do that here.
Well, because I think the commission did look at, did take that into consideration. Was there notice here that you may have to upgrade your facility in response to the changing conditions on the grid? And it looked at section, appendix C, section B3, which talks about this very circumstance. Now, granted, that only deals with changes by New Hampshire transmission, or it's only between the two.
Bilateral contract.
But the language in interpreting what the commission found it highly relevant in interpreting what is required by good utility practice. And if you look at what that section.
Isn't that bootstrapping to say, we're going to take a good utility practice and with reference to what two parties agreed to in a bilateral contract. It's sort of bootstrapping a bilateral contract into a general good utility practice.
I don't think so, Your Honor. The way the commission looked at it is section B3 is evidence of what good utility practice is, that there could be changes outside your fence line. And just a quote from section B3, that could require you, in accordance with good utility practice, to make your own upgrades. And the commission is saying this, that concept that you may have to respond to changes on the grid is inherent in good utility practice, as evidenced by the agreement between these very parties, ISO New England, New Hampshire Transmission, and Seabrook. So I don't think it's bootstrapping or imposing an unforeseen obligation. It's the notion that you may have to.
Well, it's an unforeseen obligation as to Avangrid, not as to New Hampshire Transmission.
Well, yes. I mean, again, but the commission's point in here is.
Well, and it does seem unforeseen if you can't point to any example where a generator has been required to do this.
But I would push back that it's not unforeseen because the parties foresaw it here. And the commission.
With respect to each other.
Right. And what the commission said in the initial order was, under what conception would good utility practice require you to upgrade your system in response to a change this party made, but not somewhere else in the grid, when the consequences, the undisputed consequences, that if the Avangrid project hooks up, it exposes them to significant risk.
That would be a nice policy argument, and FERC could have made that if it found that it was unjust and unreasonable to not let Avangrid connect, but it didn't do that.
Again,
it had an opportunity to. It actually sua sponte initiated 206 proceeding. 206 was brought up, by the parties.
Correct, but the commission found that there was sufficient language in the agreement that evidenced this obligation. It looked at section B3 to illuminate what good utility practice requires with respect to changes on the grid.
I had understood, maybe I'm wrong, that good utility practice wasn't against the world standards, but was good utility practice within the context of a grid. Because it's a trilateral contract, right?
Correct.
Party. And so the good utility practice has to be within the framework of a grid and all the obligations that the grid itself, ISO New England, has to bring new generation on.
I think that's fair. And just fundamentally, at the end of the day here, you have a direction from the system operator saying, hey, when this hooks up, your facility is going to be subject to extreme risk. What the commission is saying is that good utility practice requires you to follow the system operator's directive in that regard.
Everyone's reading here that, well, they can't hook up, they can't. So is the theory that, I just don't know how this works, could Avangrid actually hook up and be connected and do everything but flip the switch for the power to come? And then ISO New England says they are not connected. And your circuit breaker is no good. They're flipping the switch Tuesday.
Well,
You better get a new circuit breaker in now.
I mean, there is, I think, the ultimate and.
It just says connected.
Right.
Can't connect.
Right. I mean,
They need to be connected. And when someone's connected, if it creates that problem, they have to replace it. Well, they can connect the wires, I assume, without actually turning the power on, at which point, clearly, the obligation under 9.7.5 would kick in.
yeah, I think you're right. There is a construction phase, and then I think there's a phase energization where the switch is flipped.
FERC is just saying, let's do this. I mean, I don't know where they are since this has been postponed so many times, but they must be close to that point.
I'm not certain this data interveners council can speak to that. I know the record reflects obviously that's been pushed back a ways and that it is scheduled to go to be the work needed here is scheduled to take place in the fall. But as to the overall state of the project, I'm not certain.
Thank you very much.
Thank you, Your Honors.
Mr. Konopka? Let me know if I said your name wrong.
Good morning, Your Honors, and may it please the court, Eric Konopka for the interveners. I want to start where I think we were going. There is a little bit of a misconception here that this project is being built for Avangrid. The reality is, if you look at JA 536 to 537, ISO New England was responding to a question from FERC where basically it asked if there were alternatives to this. And it said, yes, there are actually alternatives to upgrading or replacing the breaker, building a series reactor or something like that. They didn't want to do that because that would cause side effects that they wanted to avoid. It would impede transfer from northern to southern ISO, New England. And ultimately it said it would just kick the can down the road because the problem would just crop up somewhere else, right? All it would do is add back some headroom on the breaker that would get used up by other projects. So to pick up where my friend was saying, the reality is this is a directive from ISO New England, both to us and to NextEra to upgrade the breaker. And I think where he was essentially going is clearly good utility practice requires you to respond to directives from your RTO about what is required in light of changes to the grid. And the reality is the other thing that my friend the other side is ignoring is that NextEra, in fact, did 2 paper upgrades of this breaker in the past, and presumably that was in response to changes on the grid, right? It was built originally with 150,000 amp limit, and then they upgraded it to 160 in, I think, 2010, and then again in 2016 to 165. And if it wasn't for changes on the system, I don't know why they did that.
So if, assuming that's right, that good utility practices require this because the ISO says there's an interest in it, what do good utility practices say about costs?
Well, I think
good utility practices, I'm sure, are connected in part with costs, right? You have an obligation, but who has to pay?
right. So good utility practice does incorporate sort of a reasonable cost standard. And ultimately, right, one of the issues with their position, I think, is that it doesn't require an interconnection for them to need to upgrade the breaker, right? There could be lots of other things that sort of take it over the 100% mark. And many of those, they would actually have to bear 100% of the cost, right? If ISO New England
That's
came
not
out.
the situation.
Well, right, but the reality is at this particular point, they have an opportunity to upgrade the breaker when somebody else is actually footing the $18.5 million bill for all of the direct costs. Whereas tomorrow, ISO New England could come out and say, actually, you need to have a 5% margin on your breaker. And by the way, under your own LGIA, you have an obligation to pay 100% of that cost, right? All your direct costs, all your indirect costs, and everything else. Here, they're actually in an advantageous position because we have to pay all of the direct costs of that, including about $1 million to NextEra for their engineering and other personnel supporting the upgrade project. One factual question I wanted to mention is, I think I heard my friend on the other side say that the outage is 10 days and this is going to extend it by 10 days. JA 270, the average outage is actually 3.5 weeks. Our experts came in and said we thought we could do that within a week or 2. The latest schedule outside the record is it's supposed to happen in about 10 days. And this idea that somehow going to necessarily increase it by 10 days is just not supported. That is their estimate, that was their projection, but it's not necessarily going to happen. And that makes all of their costs speculative.
Where is Avangrid in the ready to connect process?
So right now, the last I've seen is that we are scheduled to interconnect sometime in 2025. Construction is underway. I think we've built about 25% of the poles. Most of this goes kind of above ground. There's, I think, some maybe below ground, but we're sort of in the process of erecting the poles and creating the lines and doing the construction of, all of the wires and ultimately the converter facility as well.
Can you physically connect without turning the power on? Get the physical connections all in place and then that's the new grid. And
right. I mean, I think, so in response to some questions from FERC, again, ISO New England had sort of suggested that there may be alternative ways for us to interconnect without replacing breaker. And ISO New England basically said, yeah, there might be ways for us to sort of monitor the system, turn it on when we're not at risk of a high short circuit, turn it off when we are at a high risk of a short circuit, but we don't really want to do that. It creates a lot of complications and other things like that. So I think
I was asking a much more elementary question, and that is, can you get all the physical structures in place so that you are connected to this grid? I assume that's what happens. And then when all the screws are tightened or whatever they are, wires connected, twisted together, there's a turn the power on. Is that right?
As far as I know, that's correct, right? We're in the process of constructing all of the necessary facilities. That'll ultimately include an interconnection to substation in Maine, and then ultimately, we would turn the power on and start supplying hydroelectric power to ISO New England. Obviously, ISO New England won't let us do that until the breaker is in place, because that's the upgrade that
Turn the
they've.
power on.
They won't let us turn the power on, right? Or they wouldn't let us turn it. They'd let us turn it on and then require us to turn it off, and it's
Right.
at high risk of a short circuit.
Thank you.
Thank you.
I think you asked for 3 minutes, so we will give you that, but we'll try to hold you that as it's.
I did misspeak about the timing of the outage. Was expected to be 23 days, and the installation of the breaker adds another 10. I apologize.
Sorry, can you say that again?
The outage is expected to be 23 days, and the breaker replacement adds another 10, the way that the schedule.
Your existing, so you are planning to already do 23 days.
We already were planning to do that. I was wrong when I said it was 10 plus 10. That's actually the money. We did upgrade the breaker to get a little extra headroom. We did it because we increased the capacity slightly of Seabrook Station. All internal. We did have to do that. We wouldn't have had a breaker that would have performed its duties, that would have been up to the task. But that does not mean we have to replace it for Avangrid.
So can I just, Counsel for Intervenor said that ISO New England could order Seabrook to have like a 5% margin, and that you would bear the full cost of that. Is that, can the ISO do that under
No.
the?
No, they can't dictate, changes in the composition of a nuclear power plant. If an ISO's authority to run the grid and a duty to watch reliability under good utility practice got FERC as far as it claims today, then, Your Honor, in your Belmont case, they should just have said every generator in New England has to change their plant to have dual fuel capability and fuel on site. They can't do that. If you look at ISO New England's brief.
Why not? Because that's regulating generation.
Yes.
Is this a jurisdictional point, or is this something about contracts?
They both lack, there's no jurisdiction for FERC to approve that, and there's no tariff or contract infrastructure to allow that. ISO New England filed a brief below, and on JA 534, they say, Article 9.7.5 does not require Seabrook to upgrade the Seabrook breaker for the benefit of another entity's interconnection to the system. As discussed above, it is the obligation of the interconnection customer to work with the affected party to effectuate an upgrade required for interconnection. Negotiate.
Why couldn't they try to do that through a 206 proceeding?
To give a
5%, the 5% margin.
Well, I think they would have no record evidence to support that being a reliability requirement, but they wouldn't have jurisdiction to order us under 206 to change a piece of generating equipment. Nor have they ever done that in the history of the Federal Power Act.
If the ISO determined that good utility practice required a 4% margin, and good utility practice is reliable grid, necessary for a reliable grid, you're saying they couldn't say to all generators on the grid, make sure your circuit breaker has a 4% reliability or margin on it, because that's necessary for the reliability of our grid.
Well,
They can't do that?
no, I don't think they can, but they would be
Who
saying
says
it's
they can?
necessary for future parties.
Who says they can't?
ISO New England doesn't have the power to dictate the equipment inside of a generating station. They have the power to say you can hook up only 3/4 of your capacity. They don't have the power to dictate your fuel supply
So
or
they
your
could
protection.
say- So they could say to you, if you've got this on the cusp circuit breaker, you now need to go down to for this reliability of the grid, because we like a 4% margin. That's industry standard. So you're going to have to reduce, they could say, I think you just said, require you to reduce your power outage so that you have that 4% margin.
That was, no, I was just making a general comment that ISO New England does have the ability to limit how much power a generator can put into the grid, but that has nothing to do with the breaker. And
They thought that there was, I'm asking the question. If they thought the way to maintain the reliability of the grid, because you or some other company refused to replace their circuit breaker, and the only way to keep the grid functioning reliably would be to say, either replace the circuit breaker or reduce your output by, do the math, whatever it is, 75, so down to 75%. Otherwise, the grid's gonna blow. They can do that, right?
no, they could tell us we have to disconnect because there's a reliability
Oh,
problem.
if they only can do disconnect, I thought you said that they can say reduce your output.
I said they can tell you as a capacity resource, you can only inject X amount of capacity. You overbuilt your plant for some reason. So they can dictate how much power you flow onto the system, but they can't dictate internal protective equipment within a nuclear power plant.
Okay.
That's the NRC's job.
Okay, any other questions? All right, thank you very much. The case is submitted.
The honorable court is not adjourned until Thursday, February 8th at 1:30 p.m.